Welcome to another edition of Podell Screencasts. Today we're going to talk about Article 5 of the Constitution, which is the amendment process. The first 10 amendments to the Constitution we call the Bill of Rights. They were ratified in pretty quick succession. The framers of the Constitution saw the need for the blueprint of government itself to change. There needed to be a way for the new system that they had devised to be flexible and to have safeguards put in place against it becoming an overreaching system. The framers set up 4 ways to make constitutional change. Only 2 have ever been executed, and we're going to talk about that in a moment. The proposition of amendments is made by either 2/3 of both houses of Congress or at an Article 5 National Convention, which is called by Congress at the mandate of the state legislatures. So 2/3 of the state legislatures can call for an Article 5 convention, and then Congress must host it and call for it. Okay? Ratification can be achieved either by 3/4 of the state legislatures assenting to the proposition, or by conventions in 3/4 of the states. Now let's take a look at how it's actually happened. There have been 27 amendments to the Constitution. All but one of them have been ratified by the state legislatures. That was the 21st Amendment that repealed prohibition. All of the actual amendments themselves have originated in the Congress of the United States. So there has never been an Article 5 convention. Now, there are movements in various states to secure them, or to secure one, I should say, and to make an Article 5 convention happen. But why does this thing exist if it's never happened before? Like, why have Article 5 conventions written into the Constitution? The answer has to do with codifying the notion of federalism into the Constitution forevermore. If you recall, the government prior to the Constitution of the United States, under which the state governments existed, was called the Articles of Confederation. And to say they existed under them is kind of a misnomer. It was a loose league of friendship. So the state governments come first. Okay? They're ceding some of their power to the new federal government under the Constitution of the United States. And so they needed a way to make sure that if the new federal government overstepped its bounds, that the state governments all by their lonesome could initiate and effectuate constitutional change to check the behemoth federal government. Now, there are ways outside of Article 5 itself to initiate constitutional change. These are somewhat extra constitutional or derivative of constitutional processes, though don't alter the actual written words. So we call them informal amendment processes. The first would be the passage of a law, such as the 1929 Reapportionment Act, which changed the way that the members of the House of Representatives were apportioned among the various states. Executive orders themselves can initiate a change in the Constitution insofar as it changes the way that laws that are ratified or passed under the Constitution are enforced. So it implicitly changes the meaning of the document itself. Supreme Court decisions can change the Constitution without changing a written word. Think Brown v. Board of Ed, right? That separate but equal was no longer a valid application of the 14th Amendment's equal protection. Political parties. There's nothing in the Constitution about political parties whatsoever. However, they and their existence initiate changes in the way that we interpret the Constitution. And lastly, by custom, right? This is sort of the unwritten rules of government. It's like not stealing a base in baseball at the top of the 9th inning when your team is up 9 runs, right? There's no written rule to say it, but it's kind of understood by everybody. Thank you so much for watching. Please tell your friends, like, subscribe to Podell Screencasts.